All right, good afternoon. This is the final lecture for the Crim 4 class, America's Courts, Chapter 15. So, again, if you are getting this lecture, I would highly suggest printing out the PowerPoint that's in Module 4 and follow along utilizing that PowerPoint so that way you can highlight areas of concern as well as write your own notes in the margin, so that way you have a good study guide later for your test as well as other assignments. All right, so we went through punishment, sentencing, and now we're actually going to the appeals process or the appellate process. So two primary purposes of the appellate process or the appellate court is error correction and policy formulation. So error correction, policy formulation, you will see that again. Error correction refers to the appellate court's correction of mistakes found in trial, in the trial process, or the actual finding, right? So in how they actually came to that finding or the finding itself. Policy formulation is a function of the appellate court to make a new law and or adjust existing law to change the circumstances surrounding that case. So those are the two mechanisms that they utilize for error correction. Error correction as well as policy formulation. One of the basic principles of our criminal and civil court system is the right of the losing party to file an appeal. An appeal is a request by a higher court to review the case to determine if something went wrong with the trial court's decision and order the trial court to correct the mistake if it is found to be wrong. The right to file an appeal has important limits and expectations. Appeal may only be filed by the parties who have lost in lower court. That means that it may not be filed by the prosecution to rehear a case if that a case was acquitted. So prosecution can't appeal to a case that they lost. This protects citizens from the idea of double jeopardy, which is a second prosecution. There are some instances where the prosecution may appeal questions of law that would not result in the defendant being put into double jeopardy, again, such as interlocutory orders. Sorry about that. I had a quick stop. Interlocutory appeal is a temporary appeal which occurs during the trial on certain pretrial rulings that substantially hinder the state's ability to proceed. An example would be the exclusion of evidence or a defendant's confession. In order to qualify for an interlocutory appeal, a contemporaneous objection must be made during the trial. The contemporaneous objection rule is a requirement that an objection be made at a hearing or trial at the time the alleged error actually happens in order to qualify for the basis of that appeal. So essentially, it's much like an objection, right? Appeals are also discretionary except in certain circumstances like capital punishment. The right to an appeal is limited to a single appeal within which all appealable issues have been raised. Most appeals following trial are heard by U.S. district courts for federal charges and state courts of state courts, which are called intermediate courts of appeal. These courts have mandatory appellate jurisdiction, which means they have to hear all these appeals. The Supreme Court and high state courts have discretionary appellate jurisdiction. We talked about that earlier, which means they can pick and choose which cases they want to hear. Right? All right. Slide 2 through 4 talks about the different types of structure, the appellate review process from the least deferential to the most deferential, as well as the steps in the appellate process. So these different courts, they talk about how their appeal courts are set up, how the different questions of law, and then how these questions are answered either by the court or by the jury or by the judge. And then the different appellate processes from being mandatory to discretionary. Pardon me. These courts are discretionary. The types of appeals, what a brief is, an appellate brief, what an oral argument is, a written opinion, and a disposition, and how what the different types of dispositions are: affirmed, remanded, or reversed. So I would suggest that you look through each one of these tables and make yourself aware of the different processes with regard to the appellate process itself. All right, so appellate court procedure. There are some basic steps in the appeal process. First is the notice of the appeal, the appellate court record, writing the appeal brief, the oral arguments, written opinion, and disposition. So we're going to go through each one of these. Excluding capital cases, the appellant must initiate the appeal. This step consists of filing the notice of appeal with the trial court. Usually takes place within 10 to 60 days from sentencing. Now, just FYI, most defense attorneys will wind up automatically filing that appeal. I say most defense attorneys, not all of them, but most of them do. From that point on, the guilty party is not known as a defendant. They are known as the petitioner, right? Because their guilt has already been established by the fact that they were sentenced. The next step is preparing and transmitting the appellate court record, which are papers, documents, and exhibits, as well as a transcript from the trial that is submitted to the appellate court for review. So the appellate court reviews, isn't rehearing the case, they're just making a determination on whether or not everything was done in accordance with procedural law in that case. Court to review will usually accompany the appellate brief, which is the written argument that sets the party's view of the facts in the case, issues raised on the appeal, which is what the appellate or the petitioner is saying, and the precedents supporting their position. So next, winning party, known as the appellee's respondent, filed a response brief setting forth arguments as to why the original decision was legally correct and should be upheld. So basically what that means is the petitioner, originally defendant, submits a brief saying where they think the trial court erred and why they did, and then the prosecution submits a brief saying that their arguments as to why the original decision, why the trial court was correct in their finding. In some instances, non-parties, such as the American Bar Association, may file a brief referred to as an amicus brief, Latin for amicus curiae, which is a friend of the court. We've seen, I don't know if you guys have been watching the news lately, but you've seen a number of these filed as it relates to current ongoing court cases that are filed by the federal government specific to, I want to say one of them was the case with regard to General Flynn being locked up. They've had a number of different amicus briefs being submitted by different outside either agencies or other interested parties, and submitting these to the court for information. And they submit these because they believe that they'll help the appellate court make a decision in the case. And obviously, amicus briefs are biased based on who is sending them, right? So the amicus brief, if it's as it relates to the defendant, or rather to the petitioner, is going to be biased towards the petitioner. And if the amicus brief is submitted by maybe another law enforcement agency or an advocate for a law enforcement agency, it's going to be biased towards the prosecution. All right, number 6, the appellate court procedure, part 2. Next step is the oral argument, which provides the opportunity for face-to-face contact between the appellate judges, the defense, and the prosecution. Attorneys for both sides are allotted a specific amount of time to argue their side of the case before the appellate court panel. Some courts have eliminated oral arguments, believing they're not particularly helpful in deciding cases, and so essentially all they're doing is looking at the information provided by the courts, the court case record, as well as the arguments by the written arguments submitted by both the petitioner as well as the prosecution. After the case has been argued, the court recesses to deliberate, and then they decide. One judge in the majority is assigned the task of writing the opinion, and the opinion is the reason given for the decision reached by an appellate court. And there are 3 types of opinions. So the first one per curiam, dissenting, and concurring. So per curiam opinion is a decision by the court as a whole, not attributed to a specific author. So essentially what they're talking about is essentially a unanimous decision, right? A unanimous decision by the court saying that the entire court agrees with our finding. The next one is, well, most judges will normally sign their opinions. In these cases, judges who disagree with the decision write dissenting opinions, and judges who agree with the case outcome write a concurring opinion. And you see that a lot, especially in the Supreme Court decisions. So you'll see, Supreme Court is currently comprised of 9 members, and those 9 members, when they have a majority rule, if you have a 5-4 split, that's kind of shaky ground. Generally speaking, when you have more consensus of ruling versus less, there is a higher precedent or higher legal precedent there. Written court opinion ends with the disposition of the case. Appellate court may affirm the original decision, which means to uphold it. So if you hear the term affirm, that means they upheld the case. They may modify the lower court ruling by changing a part, but not totally reversing it. And they may also reverse the lower court, also known as setting aside that action. Or they may reverse and remand, which means that they set aside that action and send it back to the lower court send it back to the lower court for further proceedings, which may include holding a hearing for that specific issue or conducting an entire new trial. Aside from affirming the decision, the appellate court will only modify or reverse remand or reverse and remand it if they find an error. Reversible error is an error by the trial court that is substantial. So there's different types of errors. We're talking about a reversal error is substantial. A harmless error, that one is minor and unlikely to change the outcome of the original court decision. And a plain error is the most egregious, that the appellate court finds that the substantial right of the defendant is so prejudicial to the jury deliberation that it would undermine the fundamental fairness of the trial. So again, reversible error is a pretty substantial error. Harmless error is a minor one, unlikely to change the outcome. And a plain error is a very egregious error in that process or finding. All right? Moving on to Chapter 7. Prior to the 1960s, most defendants sentenced to prison did not file an appeal because they could not afford to do so. However, the same Warren Court, which was the Supreme Court in the 1960s, decisions allowed indigent inmate access to court-appointed attorneys for the first appellate review or the first mandatory review. And so remember we talked about having counsel assigned. The Warren Court also decided that if the petitioner was indigent, that they should also have counsel through the first appellate review. Subsequent reviews would be on the responsibility of the petitioner, either by virtue of having a attorney pro bono, and attorneys will do pro bono. Some attorneys will do pro bono if they feel that the decisions may get them some notoriety. There may be some measure of notoriety that could come from getting that decision, especially ones that they feel might move them all the way up to decision in the Supreme Court, and especially if they win their petition. Criminal appeals are generally routine because they seldom raise any meritorious issues. You may see that again. As such, many of the findings are upheld by the appellate courts. Criminal appeals usually fail as a result of 2 issues. First, appellate standards of review applicable to most decision-making during criminal trials are highly deferential to trial court outcomes. So what that means is unless there is a plain or reversible error, if it's a harmless error, usually the trial court's decisions will stand. They're not going to make any changes. Lastly, appellate courts usually find that there was no reversible error committed during the trial court proceedings. And again, when we're talking about felonies, remember we did find that trial courts are very, very, especially when the charges are pretty serious, they want to make sure that the I's are dotted, T's are crossed. Everything is done according to procedure and law, and the rights of the accused, the defendant at that time, are they make sure that those rights are afforded to them, so that way their decisions are not challenged. Trial courts, much like anybody making a decision, folks, if you make a decision, no one wants to have that decision challenged, and so these trial courts do their very best to ensure that doesn't happen. In less than 10% of appellate reviews, the appellee, which is the petitioner, wins their appeal, so that's not a lot. All right, moving on to slide number 8. You can see that this is a pie chart, distribution of types of criminal appeals in the federal appellate court, and so they talk about the different types of appeals. For violent offenses, you would think there's quite a bit, but it only amounts to about 4%. Property crimes, 12%. Same thing with immigration offenses, but the bulk of it is drug offenses, and we learned early on that was the reasoning behind drug offenses is because the federal government took a really heavy-handed approach with regard to drug law, and so many of the state laws also apply to the federal government. And as you can see right now in our federal criminal justice system, many of the defendants, petitioners, and inmates, the convicted felons, are drug offenders. All right, moving on to slide number 9, post-conviction review. So following your first appeal, you can have other types of appeals, and that's what's called a post-conviction review. So the appellate process, after it's been exhausted, after you've had your mandatory appeal, the state and the federal inmates may challenge their convictions in federal court on limited grounds. Post-conviction remedies are termed collateral attacks. You will see that again. A collateral attack that is an attempt to overturn the outcome of a court case by challenging it in a different proceeding or court. The most common type is a writ of habeas corpus. I'm sure you guys have heard that. Habeas corpus is Latin for you have the body. Writ of habeas corpus is a request for post-conviction relief for issues not raised during trial, as well as violations of constitutional protections that have developed since the original trial. So they're talking about issues with regard to the trial, as well as issues with regard to confinement or punishment. So it's quite a large broad base. Following the Oklahoma City bombing in 1995, Congress passed the Anti-Terrorism and Effective Death Penalty Act that limited writs of habeas corpus in federal court and imposed a strict deadline for filing a writ, limited successive petitions, which means continuous petitions, restricted review of petitions if the claim was adjudicated on its merits in state court. It required a certificate of appealability before the petition could be appealed to federal court of appeals, and provided decisions of a federal appellate panel are not appealable by a writ of certiorari to the Supreme Court. So there was quite a few restrictions that were made on writs of habeas. Federal prisoners are not entitled to submit writs of habeas, and that's based on the 1948 Congress enacted statute 28 U.S.C. section 2255, which allows federal prisoners to seek relief in the sentence that was imposed in violation of constitutional law if the court was without jurisdiction to impose a sentence, if the sentence was in excess of the maximum amount allowed by law, so they went beyond whatever that mandatory minimum was, or rather that maximum sentence was, and the sentence is otherwise subject to collateral attack, and we learned what collateral attack was early on. So that is an attempt to overturn the outcome of the case, challenging it in a different proceeding or court. All right, so writs of habeas would be considered as one of the primary, and that's one that you need to know, is one of the primary post-conviction remedies that are not mandatory appeals. These are key developments. Slide number 10 is key developments in federal habeas corpus law, and as you can see, there's a lot of them, starting with Brown v. Allen in 1953 all the way up to 1996 in Murray v. Carrier And so, again, make yourself aware of some of the findings and outcomes of these cases. All right, moving on to slide number 11, wrongful convictions. Excuse me for a second, I got to take a drink. All right. Despite all the protections of appeal and post-conviction review, there are some instances where the defendant is wrongfully convicted. In a 2014 study completed showed that 4.1 defendants sentenced to death in the United States are later discovered to be innocent, and that equates to about 1 in 25 cases. Now, if you look at it from that perspective, 1 in 25 doesn't seem like a whole heck of a lot. However, you have to bear in mind that our criminal justice system is designed with the idea that if we cannot prove beyond a reasonable doubt that these individuals did in fact commit the crime, sentencing a person to death, sending an innocent person to death is actually worse than if the crime would have been committed. So you're taking a person who didn't do what they were charged with doing and putting them to death. And in truth, that shouldn't be done to anybody. And so that's one of the arguments that is against the death penalty. On non-capital cases, the percentages range from 0.5% to 15%. Most wrongful convictions for capital crimes are exonerated by, and we learned about this in a previous chapter, by DNA evidence, and that's scientific evidence that's pretty much non-refutable. However, wrong convictions later exonerated by DNA evidence account for roughly 22% of all exonerations. Some other exonerations involve finding official misconduct by some of the criminal justice system actors, and we learned why sometimes that does happen. There's a significant amount of pressure that's put on prosecutors to get guilty convictions, to get guilty findings and get convictions, right? And sometimes it'll lead to this misconduct by the prosecution and to the courts to a lesser extent. Defendants pleading guilty even though they were innocent to avoid lengthy prison sentences and exoneration due to finding no crime actually occurred, such as false claims of domestic violence, and we do see that quite often when we saw the metrics for making a determination on punishment for domestic violence lean heavily towards the victim, right? And so sex offenses, domestic violence, there is a lot of especially now, I'm sure you guys have heard Believe Her, the Believe Her movement. And so with a lot of that, when those biases are filtered down into the criminal justice process, there's going to be instances where individuals are found guilty when in fact they didn't commit those crimes. Wrongful convictions occur for a number of different reasons. Many of them include mistaken eyewitness identification, tainted forensic evidence, improper laboratory practices, contaminated samples, poor police work with regard to the processing of this evidence, and we learned about the chain of custody in an earlier discussion. So all these play a part. And again, false convictions, we learned that some people will bear false witness based off of relationship or the dissolving of one. Many of these confessions are done as a result of duress, coercion, intoxication, diminished capacity, mental impairment, ignorance of the law, fear of violence, the actual infliction of harm, threat of harsh sentence, and a misunderstanding of the situation. So we don't know. We do know that people make false allegations, but oftentimes it's really difficult to find out the motivations for those allegations. They could be deliberate and with the intent to harm, but they also could be, as a result of a diminished mental capacity, diminished memory, a length of time that occurs between the incident and the point of recollection. So that does happen at times. Unreliable informants also provide false or misleading information. Prosecutors in the court who are goal-focused in finding a defendant guilty, also ignoring the exculpatory evidence also known as tunnel vision. So again, we talked about why they do that. They have that huge amount of pressure. And again, I don't want you to misconstrue. I'm not using it as an excuse. I'm just noticing you that sometimes those additional pressures of success that are placed upon them politically will introduce those wrongful convictions and those unethical decisions to be made. So it is something that does need to be considered when we're dealing with these convictions. We need to, truth be told, hold ourselves to a higher account in the judicial process. All right, state court of last resort. So we talked about the state court of last resort, much like the Supreme Court, is an appellate court. They have the ability and to actually conduct a trial, but for the most part, they are looking at trials that have already taken place. So 10 states and the District of Columbia only have a state court of last resort. They don't have an appellate court. Here in California, we do. The other 40 have at least one intermediate appellate court, sometimes two. By having the intermediate appellate court, this allows the state court of last resort to focus on advancing public policy by clarifying the law, which is one of the primary responsibilities of the state court of last resort. And we can see that, especially in the federal government with the Supreme Court of the United States. They clarify the law with regard to their case decisions, and those case decisions act as precedent on all other decisions that are similarly situated in lower courts. Okay. Now, the only one who can supersede that decision is the Supreme Court. So they also, but in doing that, they really have to look at case law as well, right? And so we've seen the Supreme Court of one court, and that's also based off of the advancement of technology and our society and moral standing that sometimes gets introduced into case law, much like it does into statutory law and pretty much in even executive law and executive writ. When we have that happen, other courts will look at it and make those changes as well. Interpreting statutory law and state constitutional provisions is the way the state Supreme Court has important government policy, is important government policy makers, right? So they make sure that statute is lawful under, one, the existing criminal statutes, two, the Constitution of the United States and the state constitution. This is sometimes referred to as new judicial federalism, which refers to the movement in state Supreme Courts to reinvigorate state constitutions as a source of individual rights over and above the rights guaranteed by the U.S. Constitution. So we learned that the U.S. Constitution is the minimal amount of rights that are granted. States can also grant additional rights above the rights that were granted by the federal government, but they cannot restrict the minimum rights considered human rights or natural rights of the federal government. So the federal government's rights that are granted, and we consider them substantial in comparison to other nations, but in actuality, the states still have the ability to grant additional rights of their own above the rights of the that are granted by the state government, or by the federal government rather. And these rights are not rights to government; they're rights to the people. Right? Remember, our Constitution doesn't give rights to government. Our United States Constitution limits government intervention into the lives of the people, and that's what kind of makes it a unique document. Okay. Wow, we're here. The last slide, chapter 15, slide number 13, the United States Supreme Court and the criminal justice policy. So the United States Supreme Court is almost exclusively discretionary. Most of the cases, about 80%, are reviewed. They are civil, and the rest, the other 20%, are criminal. Through the years, the Supreme Court has been identified according to their Chief Justice. So you'll hear like when you hear the Warren Court, which was from 1953 to 1969, it was Chief Justice Earl Warren. Right? Warren Court addressed many cases surrounding civil liberties and civil rights. Some of the landmark cases included Brown v. Board of Education in 1954, which invalidated racial segregation. And a number of states had a very difficult time with that, which required federal intervention in the upholding of that law. And another landmark case was Mapp v. Ohio in 1961, which clarified what the exclusionary rule was. And again, we learned what the exclusionary rule was and how it relates to evidence. Burger Court from 1969 to 1986 was a more conservative court that amended some decisions such as Mapp, where it created the good faith exception, where when we did talk about that prior to the exclusionary rule, there were some cases where evidence can be introduced, and that would be under the good faith exception to Mapp. Rehnquist Court from 1986 to 2005, also conservative court, curtailed abortion rights and condoned mandatory drug testing and permitted capital punishment for juveniles and developmentally impaired persons who were convicted of murder. Rehnquist Court also reduced habeas corpus relief. And then the current court, which is the Roberts Court, was from 2005 to present. Also conservative court. However, if you want to, if you look at that more recently, the Roberts Court, even though Roberts is a conservative, he's been siding a lot lately with some of his more liberal colleagues in the Supreme Court, especially in the area of the Second Amendment, which has been, in my humble opinion, kind of a mistake. So, however, there are some significant liberal presence in the Roberts Court. Justice Ginsburg, Breyer, Sotomayor, and Kagan. Some of the significant cases that they have heard: Ayers versus Belamonte, 2006. The court ruled that juries don't need to consider future mitigating circumstances during sentences that sentence deliberations. And James v. United States in 2007, where the court found attempted burglary qualified as a violent felony, upholding 15-year mandatory sentence under the Federal Armed Career Criminal Act. And we learned, Crim 1, you should have learned that burglary doesn't necessarily involve theft. It is the commission of a felony in an occupied dwelling, right? So that's one of the reasons why that court found the attempted burglary qualified as a violent felony. So that kind of goes through from 1953 to present, the different Supreme Courts and how they are identified. And that concludes the lecture for Chapter 15, and that concludes my lectures to you in this class, in the Crim 4 class. Hopefully you have gotten as much as I've given, and more so. I wish you well in your upcoming exam, and in all your future educational and job endeavors. And hopefully when this COVID-19 is all over with, and I'm back on campus, please make it a point to stop by in my classroom and say hi. And I'd love to hear from you and see and hear and see how you're coming along in your educational, with your education as well as your career goals. Again, thank you so much. It's been my pleasure, and I wish you well again on your exam and in all your future endeavors. Again, if you have any questions, issues, comments, or concerns, please feel free to get a hold of me. And until next time in one of my other classes, I hope to see you soon. Bye-bye now.